FIR. So the BNS also introduced the provisions of electronic FIR, allowing FIR registration through electronic means. So now there is a process that you can even register the FIR without going to the police station through websites. Okay. The provision serves as a significant relief for the victims, especially women, by expediting the registration process and preventing them from reliving traumatic experiences while reporting crimes. So this facility is mostly advantageous to the women or the sections of the society that cannot access to police stations frequently. Okay. So while this development is a positive step towards timely and sensitive cases registration, it raises concern about unregulated online FIR registration. So see, once the process has become online, everyone, for even slight crime, they will try to register an FIR. So it is telling that while it has certain benefits, it has certain backdrops also. Okay. So the Parliamentary Standing Committee recommended that such registration be allowed through specified modes regulated by the state to avoid logistical challenges and proliferation and unmanageable FIRs. So only the cases that are really very sensitive, only for them the online FIR should be allowed. This was the main contention of this. The BNS now also includes a provision for lodging information electronically under section 173(1), requiring the informant's signature to be obtained within 3 days prior to the official recording of EFIR. So once you have registered the EFIR, your duty is not over. Okay, within 3 days from such registration, you have to go to the police station where you have registered the FIR and you have to physically go and sign there. Okay. Next, preliminary inquiry. So section 173 subclause 3 of BNSS now introduce the concept of preliminary inquiry. Please underline the word preliminary inquiry before registering an FIR. So this is very important. First what used to happen, you go register an FIR, the case gets registered. But now this provision has been changed. Once you go to the police station stating that some incident happened, the police officer will not instantly register your FIR. They will first inquire about the matter. They will go to the spot, whether the incident took place or not. They will inquire about everything and then only they will register the FIR. This is a very new concept that was introduced this time. Okay. So before registering an FIR aimed at determining the existence of a prima facie case involved, underline the word prima facie phase, involving cognizable offence punishable with imprisonment between 3 to 7 years. This inquiry must be completed within 14 days. Please underline the word 14 days. It specifies that upon receiving information about such offences, the senior police officer in charge can either conduct a preliminary inquiry to establish a prima facie case or proceed directly with the investigation. Permission from the Deputy Superintendent of Police or a higher rank is required to conduct this preliminary inquiry. So this preliminary inquiry will be conducted by the superintendent under the direction of Superintendent of Police Officer or some higher rank of police officers. Now a very important and emerging topic is concept of zero FIR. So zero FIR, that is also an FIR, is a concept that is introduced to ensure that the cognizable offence can be reported and registered at any police station regardless of the jurisdiction where the incident occurred. Okay, so I will just tell you. First, there was a law that, for example, an incident took place in a specified area. So you can only report the incident to that particular police station. But now when the concept of zero FIR has come, the area doesn't matter. Even if the incident took place somewhere else, you can still register a zero FIR in your area. Okay. And the police officer, after being satisfied that the incident took place, then he will transfer the copy of your FIR to the place where the incident took place. Now the idea behind zero FIR is to facilitate the prompt registration of complaint without any delay, especially in the cases where immediate intervention is required. Certainly the inclusion of zero FIR provision is beneficial for the victims since police officers are obligated, please underline, since police officers are obligated to record the initial information irrespective of the territorial jurisdiction. Wherever the crime took place, they have to first register it. Please underline the word territorial jurisdiction.
Yes, ma'am.
The word in section 173 subclause 1, irrespective of the area where the offence is committed. Please underline this also. Remove the jurisdictional barrier. So this concept removed the jurisdictional barrier in registering of FIRs. Now it is important to observe that the concept of zero FIR is not a recent introduction in Indian criminal law. In 2015, advisory from the Ministry of Home Affairs, the government recommended filing of zero FIRs, especially for the crime against women. Furthermore, the judiciary has consistently emphasized the necessity of registering zero FIRs in various cases. For example, in the case of AP versus Punati Ramula and others, the Supreme Court held that the constable should have recorded information about a cognizable offence and forwarded it to the police responsible for that area. Same thing I told now. See, they have to register the FIR and then they have to send it to the concerned area wherever, whichever police station has the power to register the FIR, where the crime was allegedly committed despite any territorial jurisdiction limitation. Now BNSS 2023 has now given a statutory mandate for zero FIR under section 173(1). Please underline that section.
Yes, ma'am.
Yeah. So when a person wants to report a crime, then they can go to the police station to file an FIR even if the incident does not occur within the police station's jurisdiction. The police station where the report is filed then registers the case with a temporary number known as zero FIR and initiate the investigation. Subsequently, the case is transferred to the police station which has the jurisdiction where the offence took place. It helps to ensure that the legal processes start promptly and the investigation is not hindered by any jurisdictional issues. Now we will look into what are the requirements and advantages of maintaining a transparent record of FIRs. So it increases transparency and accountability. Transparent record ensures that the actions by the law enforcement agencies are visible to public, fostering a trust and accountability with the community. Then promoting fairness and due process. So by documenting the initial complaint or allegation, FIR records provides for the starting point of legal proceedings. Please underline the word starting point of legal proceedings.
Yes, ma'am.
Yeah. Ensuring that the individuals are treated fairly and in accordance with the due process. Then through the impartial investigation, clear and accessible FIR record facilitates through investigation by providing a detailed account of the reported incident, enabling the law enforcement agencies to gather evidences and pursue the leads effectively. Then increase public confidence in the legal system. So transparent FIR record demonstrate a commitment to openness and integrity with the justice system, thereby enhancing public confidence and belief in the fairness and legal processes, then deterring criminal behavior. So publicly available FIRs act as a deterrent to the criminal behavior by signalizing that unlawful actions will be documented and investigated, potentially reducing the occurrence of the crime within the community.